let's say some more about this lack of constitutional protections for individual rights, having discussed how the Bill of Rights addressed some of those and was important for winning over people in the anti-federalist camp. And the point I want to make here is that the anti-federalists were not mistaken when they said that protections for individual rights in the Constitution were very limited. As we go through these, I'm going to guess there's going to be maybe one of these that you're familiar with. If it's more than one, you're probably way ahead of the curve on this thing. And to take a step back from this, remember when we talked about the Federalists, they weren't really worried about the federal government trampling on rights because they expected that we would have these kind of enlightened, independently wealthy gentlemen who weren't in government for the power running the show. And so they would have no selfish motivations for what they did, and so they wouldn't trample on people's rights. And beyond just the strong Federalists, the committed Federalists, most of the delegates to the Constitutional Convention really did think that protections at the state level were enough to ensure protections for individual rights. And as a result, outside, we are talking only about the Constitution itself and not amendments. There are only a few protections that are offered. And as I said, they're kind of what we would think of as kind of obscure things that really don't get talked about much. One of those is protection from what are called ex post facto laws, meaning after the fact. And the idea here is the Constitution says you cannot punish a person for something that they did that was not illegal when they did it. So if time period A, a person crosses the street outside of a crosswalk, and there's no law against jaywalking when they do that. What they're saying is the Congress could not then pass a law that made it illegal to cross the cross without a crosswalk, and they punished the person who had done that thing before the law against it was passed. And I know Congress is not in the habit of making laws about things like jaywalking, but just want to kind of illustrate the point. There was also a prohibition against bills of attainder. And what this was, a bill of attainder would be a piece of legislation that was passed specifically for the purpose of punishing a person. It would be an act of government to punish a person. This would be a punishment that was not the result of judicial due process. There's no charging by a prosecutor. There's no trial before a jury. There's no defense for the accused. There is just a bill saying we are punishing this person. The Constitution says you cannot have those. This is the one I think probably, if you've heard of any of these at all, it's probably this. Maybe ex post facto, but probably this. And that is the writ of habeas corpus. And habeas corpus itself means you have the body. And before we talk about it, the Constitution says that essentially the right to a writ of habeas corpus cannot be suspended in the United States except in cases of war or insurrection or rebellion, to mean the same thing as insurrection. And so what this protection is for arrested people. A person who has been arrested and is being detained, maybe kept in a jail, has the right to ask a court for a writ of habeas corpus. If the court issues this writ, then the law enforcement authorities holding the accused person have to go before the court and justify the continued detention of the accused person. What this really boils down to, the thing that most people remember, and it is the most important thing, essentially what the right to a writ of habeas corpus does is means that law enforcement cannot arrest you and hold you indefinitely without charging you. They have to charge you or let you go. And so that, I mean, it is an important protection, and that's why, of these, that's probably the one that's most familiar to people. Um, there is, oddly enough, one crime and one punishment specifically mentioned in the Constitution, and that is that treason is a crime, so betraying your country is a crime, and it is punishable by death. At the same time that we have that in the Constitution also makes proving this capital offense difficult. Um, Essentially, what has to happen is, well, I don't even know if it's essentially, it's pretty much what has to happen is a person has to confess that they are a traitor, they committed treason in court, or you have to have two witnesses that will testify to this traitorous act in court. And I know the two witnesses thing maybe seems like a fairly low bar, but the testimony they give is going to have to be pretty damning in order to convict a person of treason. And so you kind of have this odd balance of we treat treason as an offense punishable by death, and we make it really hard to prove. To help you maybe understand the rationale for that in the Constitution, remember, the people that are working on this thing were only a few short years ago themselves traitors guilty of treason against the British government. So, I mean, you can imagine that they have, if not sympathy for people accused of treason, they can at least empathize with people accused of treason. And another thing that's built in here, that we're going to think about the separation of church and state much more explicitly in the First Amendment, okay, but it is also in the body of the Constitution itself. There can be no religious qualification for jobs. You don't have to promise to be a Protestant, swear that you are a Protestant, renounce the Roman Catholic Church, anything of that nature in order to be qualified for a government job. You should be able to get it regardless of your religion, and nobody should ask. And in here, there is also, in Section 3, which we'll see is the section of the Constitution that deals with the judicial branch, there is kind of this basic notion that people have a right to a trial by jury, or there's at least a guarantee that people will have that. And of course, we'll see that. You, in fact, have already seen it looking at the Bill of Rights for the Sixth Amendment, especially, but also the Sixth Amendment's about criminal cases, and also in the Seventh Amendment, which is about civil cases. We mostly don't talk that much about the Seventh Amendment. We focus on the Sixth Amendment because that's more serious. That guarantees you a right to trial if you are accused of a crime. And so those are the few protections that are in the Constitution. And we'll work later to make sure we have a quick reference sheet for this, because, again, a lot of these are kind of obscure and they're easy to forget about, especially in comparison to the Bill of Rights. And that concludes this part of the presentation. When we come back to the Constitution, we're going to talk about the ways of changing it. And it's going to be a more complex picture than simply amendments. So be kind of prepared to have a lot on your mind as we go through ways of changing the Constitution. All right, until next time.